Hello and welcome to this class on the subject matter of copyright. In this class, what we're going to be talking about is the kinds of works of authorship that are protected by copyright, or rather maybe which parts of a work of authorship are and can be protected by copyright. But in order to get there, we're going to have to take a step back and talk about where copyright comes from. So the authority for Congress to create copyright protection in the first place comes from the Intellectual Property Clause, which gives Congress the power to give inventors and authors exclusive rights in their inventions and works of authorship for a limited period of time for the purpose of promoting the progress of science and useful arts. So sort of implicit in the Intellectual Property Clause is not only the idea that Congress has the power to create copyright, but also that there are certain limitations on Congress's power to create, or at least to grant copyright in certain kinds of works of authorship, and that those limitations are tied to the reason that the power to create copyright protection exists in the first place. Okay, so what does that mean in practice? What actually happened? Well, copyright has a long history, and Congress has granted copyright in many different kinds of things, in many different kinds of ways over the last 200 plus years. But let's fast forward to what copyright doctrine and what copyright law looks like today, because that's the most relevant version of copyright for us to be talking about in the moment. So the part of the Copyright Act that defines statutorily the subject matter of copyright is Section 102A of Title 17 of the Copyright Act, which provides that copyright protection subsists. In other words, there is copyright protection in original works of authorship, fixed in any tangible medium of expression, with a whole bunch of expansive language attached to it, essentially saying you can fix it in a tangible medium of expression in any way you want to. It really doesn't matter what it is. We're indifferent as to the nature of the medium in question. So the fundamental requirements here are originality of a work of authorship and fixation of that work of authorship. So we've got two different requirements, two fundamental requirements for copyright protection: originality and fixation. So what do those two requirements actually mean? Like, in other words, what are originality and fixation, and how do we know whether or not a work of authorship has those qualities? Well, we'll be talking about that extensively in future lectures, but I wanted to give you a really brief overview of how each of those works. So originality goes to what we expect, what kind of qualities we expect the work to have in order for it to qualify for copyright protection in the first place. And fixation goes to what we expect the author of that work to do in order to claim copyright protection. Now, how do you get a copyright? You simply create a work of authorship that has these two qualities. In other words, as soon as you create an original work of authorship and fix it in a tangible medium, then you own a copyright in the work of authorship that you've created. That's all there is to it. That's all you have to do. But what does that mean? What do you actually have to do in order to make that happen? Well, originality is the most fundamental requirement of copyright protection. It's a constitutional requirement. And as we'll learn later, Congress has said, or rather the Supreme Court has said, that Congress can't grant copyright protection in works of authorship that don't have this quality of originality. In other words, if a work isn't original, it can't constitutionally be the subject of copyright protection. That might also be true of fixation, but it's not entirely clear. So we'll talk about that more later in the class. In any case, what then does this constitutional requirement of originality mean? Well, essentially, in order to be original, a work of authorship has to be independently created by the author of the work and have some spark of creativity. Okay, well, what does that mean? Well, in order to be independently created, it means the author of the work actually had to generate the work in question. In other words, if the work was made by the author of the work, then it can be protected by copyright because it's original. But if they copied it from somewhere else, then it wasn't independently created by the author, and it can't be the subject of copyright protection. So essentially what we mean when we say originality and independent creation under originality is that as long as you didn't actually copy it from somewhere else, it's independently created by the author of the work and therefore presumptively original for the purpose of copyright protection, so long as it has this special sauce that the Supreme Court has come to refer to as creativity. Now, what is creativity? It's really unclear, but whatever it is, you only need a tiny little drop of it in order to qualify for copyright protection. In fact, you need so little that you might as well not need any at all. And we'll talk about what that means and why that is in our next lecture on the case Feist v. Rural. But there's another important point to take away from this as well, right? Because when we say, is the work independently created? Well, usually works consist of some parts that are independently created by the author and some parts that aren't, right? Like, so for example, when you write a law review article or a case book, you write some of the sentences yourself, but other sentences you copy from other places and put quotation marks around them and add a citation, or maybe you copy entire cases and just cut some parts out and stick it into the case book for students to read. Those parts of the work aren't independently created by the author because they're copied from somewhere else. So those parts can't be protected by copyright, but the parts that were independently created by the author can be. In other words, when we talk about copyright protection of works of authorship, really what we're talking about usually isn't the work as a whole, but rather specific elements of a work of authorship, the elements of the work that were actually independently created by the author of the work and added to the work by that author when they created it. So an important takeaway here is to think about works of authorship not in the aggregate as unitary wholes, but rather as wholes that consist of lots of different parts, and the parts are where the real action is, right? The parts are where the copyright analysis really takes place, and it's by looking at the parts of a work of authorship that we can determine which parts are actually protected, and therefore which parts could be the subject of a copyright infringement action if somebody copies them without permission. Now, there are certain limitations on the scope of copyrightable subject matter, right? One of the most important ones being what's often referred to as the idea-expression dichotomy, which we'll talk about a lot more later in this class. But fundamentally, what it says is that copyright can only protect concrete expressions. It can't protect abstract ideas, right? So in other words, a work might have lots of different elements, some of which are specific phrases, for example, or particular ways that the work looks, but those might be expressions of broader principles or broader concepts. Well, copyright goes to what you actually wrote and recorded, not the ideas or the themes or the concepts that are in the background of those particular expressions. So essentially, the concrete expressions that you make in a work, those are the subject matter of copyright. The abstract ideas aren't the subject matter of copyright. And in fact, they probably can't be, right? They're probably outside the scope of originality, even though they might actually be quite original. The Supreme Court has certainly alluded to the idea that ideas must be constitutionally excluded from the scope of copyright protection in order to ensure free access to ideas.